Kia ora koutou katoa. Welcome to webinar 3 about chapter 3 of the legislation guidelines. My name's Guy Beetson. I'm the Deputy Chair of the Legislation Design Advisory Committee, and I'm also a General Manager at the Institute of Directors. There are 3 parts to our webinar today. We're going to start with a short presentation. We're going to move to a panel Q&A, and I'll introduce the panel after the presentation. And then we're going to open up to you, the audience, for some questions and answers on the matters that are raised through the course of the webinar. So welcome again. And I'm just going to play the presentation. Tēnā koutou katoa, nau mai, haere mai. Welcome to the LDAC webinar series. Through this webinar, you will learn about chapter 3 of the guidelines. Before turning to our panel to answer some questions about this, we will provide a brief overview of LDAC and its role. The Legislation Design and Advisory Committee is made up of members appointed by the Attorney General to support good legislative design. It's a mixture of public service and non-public service members. All members are voluntary or unpaid for their LDAC work. In the case of the public sector employees, their time is loaned by their employer. PCO provides secretariat support, including advisors to support the committee. Members have a broad range of backgrounds. We draw members from legal and policy teams within departments and Crown entities, as well as academics, lawyers, barristers, and consultants. A broad range of skills and experience is important because good legislative design is multidisciplinary. It's not just about the law. We have 3 functions. We publish and maintain the legislation guidelines and supplementary material. That's Government's Handbook for Good Legislative Design. The most recent edition was updated in 2021, but the guidelines have a decades-long history and are direct successors of the LAC guidelines. We carry out education and engagement activities, like this session today, but also by department and by issue. Both these activities extend our reach beyond our advice function. It's common to see submissions to select committees refer to the guidelines, and ministers are required to address consistency with the guidelines and cabinet papers for bills. Our advice function applies at 2 different stages. The bulk of our work is prior to introduction, when we advise departments that come to us. And we also make submissions to select committees. We aim to support good lawmaking. We are guided by the guidelines and supplementary material. The guidelines are not about policy. They are about expression of policy in law. This means you will not find us giving an opinion on policy. It's important to remember that the guidelines are just that, guidelines. These are not rules that must be followed. Our goal is to help ensure that conscious design choices are being made. Today, the focus of our webinar is on Chapter 3 of the legislation guidelines, how new legislation relates to the existing law. We will start with how to identify existing law and why it is important to do so. We'll then move on to how to manage the relationship between new legislation and existing law. And we'll finish with a discussion about how and when to use precedents from the existing legislation. So that gives you a bit of a flavour about the Legislation Design and Advisory Committee and what we're going to talk about in today's webinar. Before we move on to the substance of today's webinar and the Q&A, we'll just want to introduce the panel we're fortunate to have today, who comprise an experienced lawyer with quite a lot of interactions with policy and an experienced policymaker with quite a lot of interaction with lawyers and the law. So if I turn to Alison first, do you want to introduce yourself?
Sure. Kia ora, I'm Alison Bennett. I'm a Director of Legal Services at MB and also a member of LDAC.
And John?
Kia ora tātou, I'm John Sutton. I'm a Principal Policy Analyst at the Department of Internal Affairs and a member of LDAC.
So we're going to divide this into 3 pieces. We're going to start with identifying the existing law. So if I can turn to John first, and Alison actually, why is identifying the existing law important? Perhaps I'll start with Alison.
The bottom line is, Guy, that legislation doesn't operate in a vacuum. It forms part of a wider regulatory system and that is usually comprised of both formal and informal rules, which shape people's behaviour and seek to achieve broad policy goals and outcomes. So the purpose of new legislation for the most part is to change how the system operates. And that might be in response to a change within the system, such as developing technology, or a change in the outcomes that are sought at a higher policy level.
And what's your view of that, John?
Yeah, it's incredibly important to understand the legal context in which your proposals exist, which is both about how that context might contribute to the policy problem you're trying to address, but also how it might limit or provide the context for your legislative solutions to that problem.
Yeah, and I guess from both your and my perspective in the policy advice profession, that context is often the piece that's missing from policy. And I guess what we're saying is that context matters equally in terms of legislative drafting and design. So I guess we should turn on, we've identified clearly that the existing law can be in the form of legislation or the common law. So I guess, John, turning to you first of all, in your role at DIA, can you talk us through some key steps in identifying existing legislation?
Well, I think it's useful to think about the existing legislation in two categories. The first one is the legislation that relates directly to your topic or your objective. That will provide the context. It may also provide the opportunity for your policy solution. A lesser or a later issue, I guess, is what effect will your proposed legislation have on other legislation? You need to be very clear that that is what is intended and you don't create any unnecessary problems for any other policy or legislation.
Yeah, it's an interesting one, actually. I've always been amazed in the work that I've done from that policy perspective, turning policy into legislation, just how good the lawyers and the law drafters are about identifying that legislation. What's your experience been?
My experience is it's a lot easier now that we have legislative databases and good search engines and so on. But you still need to use a range of initiatives to try and identify it. It's usually pretty easy to identify the thing that's most directly relevant to what you're doing, and often you're going to be amending an existing act. But you just need to be able to think quite laterally to think what else might be affected or what else might be impinging on your policy.
And how do you think, John, in terms of your policy experience, how do you think lawyers in this context, in terms of identifying that existing legislation, how can those lawyers help policy advisors work their way through this best?
Well, I think they probably have a broader, if you like, overview of the legislative landscape, and may be able to identify some of the key sort of legislative or legal relationships between what you're proposing and what existing law covers, including, and very importantly, law that may be administered by another department. It's often a pitfall to ignore that or to leave it too late to deal with that.
Yeah, it's interesting in terms of what you've talked about, John, in terms of just being able to identify the existing law more easily now than perhaps we could in the past. But if I can turn to Alison, and this, I guess, is particularly an important part of the law. We've talked about legislation, but the common law and tikanga also have a role in here. What are the key steps in identifying existing common law and tikanga, Alison?
Sure, thanks, Guy. Yeah, the starting point here is really that as far as practicable, legislation should be consistent with fundamental common law principles. So it's really important to have a really good think about this up front and be clear about where you might be, where the common law might already play a part in the context, or where you might be impacting through your proposed legislation. So a considerable amount of New Zealand substantive law is still found in common law. So this includes large portions of the law of tort, which is sort of civil wrongs that are actionable in court, the law of contract, and equity, which includes the law of trust and fiduciary obligations. So quite important stuff that impacts a lot of people day to day. And that also includes principles of judicial review, of course, which will be relevant as you work through legislative solutions. So you need to sort of work through some questions around these things. You need to be asking yourself whether there are any existing obligations or remedies in this space available at common law. So is there a way that the common law actually already acts to help to sort of contribute towards solving the problem that you've identified? And you also need to be alert to any risks that you're creating through legislating. So, for example, might you be imposing a duty of care between groups, which in turn might create an avenue for a claim of negligence. It's also really important to remember that common law recognises tikanga, Maori customary title, which is akin to a property right, and customary rights, which may include rights of use and access in both land and other natural resources. So recognition of tikanga, Maori customary title and customary rights are not dependent on the treaty. That's another important point. They actually sit within common law. So early engagement with Maori is going to be really important to help assist identify and understand the nature of existing Maori interests. It's also important to remember that tikanga may differ between iwi and hapu, so appropriate tikanga to be followed will become another practical issue you have to grapple with. And in this respect, Crown Law, Te Ara Whiti and Te Puni Kokore have lots of expertise and are able to help you identify those and work through those interests that might be affected. I'll just note that we've skimmed over this very lightly today, but Crown Maori relations are a whole separate topic in itself and a likely subject of a future webinar, so watch this space.
And it's interesting too, I guess the other space to watch is what the judiciary is actually doing in this common law and tikanga space as well. And somebody said to me the other day that they thought that the kind of silent revolution that was going on was around this common law and tikanga space. Is that your sense of it too?
That's right, I think so. I mean, usually we think of the common law as a beast that evolves very, very slowly over hundreds of years. But my sense is that that recognition of tikanga has rapidly evolved in the last few years, and I suspect will continue to do so in coming years. So it's certainly one that that policy and legal advisors should keep an eye to and think about how it impacts their areas.
Yeah, so thank you both in terms of helping us to work through that that focus on the existing law and the context. It's really important to get a clear understanding of that existing law, including common law, at the outset of your policy making, not something that you deal with at the end. There's obviously conversations to be had, so this is not an easy thing. It's not something where you go and look it up in a book and there it is, and hey presto, you've got the existing legislative frame, both in terms of the legislation and the common law stuff sitting there for you. So that's kind of what I should have suggested at the outset, though, that, and Alison's talked about questions, I guess I should encourage the audience to put questions in the Q&A box at the bottom of the screen. You feel free to ask those questions as we go along, and we'll pick those up after we've worked through this question and answer with the panel. So we could turn to John now about the principles and managing the relationship between new legislation and existing law. So what are the key principles to take into account when managing that relationship between new and existing law?
Well, I think the overriding one is that any new legislation should improve certainty. It certainly shouldn't reduce it. And there's a number of sort of subsidiary principles that help to achieve that. One is that generally new legislation shouldn't restate anything that's already covered by existing legislation. If you duplicate law and one of those provisions is subsequently amended, it can create a lot of confusion, a lot of doubt. And there's no need to do that. Sometimes it's useful to point to provisions in other acts that apply in your legislation, but you don't need to actually duplicate those provisions. If you are trying to do something different, or your context requires something that is different from what is provided somewhere else, you just need to be very clear that that is the case, and be very clear about what applies and when it applies. And finally, I think that the other one is, it sort of relates to the common law, is again, you don't need to deal with things that are satisfactorily dealt with the common law. There can be some reasons for doing that, but generally, if the common law applies, it's only going to be confusing to try and legislate in that space.
So what's your view, and what do you think LDAC's view is of that codification of developments in common law? I mean, I guess the reason I raised that is obviously if you look at, far back enough, I guess, some of the Law Commission's recommendations on something like the Companies Act, or indeed some of the more recent changes to the Incorporated Societies legislation, both of those from a policy perspective would say they were codifying the common law. What's LDAC's view of that?
I think LDAC's view is that there can be advantages in doing that, particularly in the case of law that has to be applied and understood by a wide range of people. It can be much easier to access it if it's set out in the statute, but there are risks in that you're making something which is intended or is history is dynamic. Suddenly you are codifying it, you're making it more rigid. And I think you're never going to codify everything in the relevant common law, so you need to be very clear about the relationship between what you are putting in legislation and what remains.
So you've talked about the principles, John. I mean, you've worked in this policy to legislation area for a long time. What's the best example you've worked on in terms of managing that relationship between you and existing law?
Probably, I don't know if it's the best example in terms of good practice, but the biggest example is probably the Auckland Super City legislation, where we were creating a unique local authority with some bespoke powers and duties within the framework of local government law generally. So we had a considerable body of work to identify where we wanted to deviate from the provisions in things like the Local Government Act or the Local Electoral Act, and where those provisions should apply, and being very clear about that. It was also not just limited to local government legislation. The Land Transport Management Act in particular has some special applications in Auckland that we needed to manage. And we tried to be very clear about how that happened, though there is a provision in the Auckland Council Act that says, in the event of any inconsistency, the Auckland Council Act overrides it.
So we do see examples of that. And I guess that raises a really important point, which I'll turn to Alison now about, which is we haven't really touched on bespoke legislation properly. I mean, John's alluded to it at some level in what he's just talked about. Can you talk, Alison, about what we mean by bespoke legislation and when we should use it?
Sure. Bespoke legislation is a term we give to legislation that's enacted for a very specific set of circumstances, rather than relying on or amending the processes that are established under general law. So a good recent example is a little bill that was passed a couple of years ago to stop a road in downtown Auckland to enable the construction of the America's Cup village that was being set up before the Cup. So essentially the bill overrode the requirements, I think, of resource management and local government legislation that's put in place certain processes that were required to be complied with before a road could be stopped. So in essence, bespoke legislation is an override of the wider regulatory system for a very specific circumstance and purpose. And for this reason, bespoke legislation really does need to be strongly justified, especially where there's existing law available to deal with the matter. You need to really work through that case for overriding or exempting from the usual law that applies. There are also a number of risks around bespoke legislation that in LDAC's view mean that Parliament should be quite cautious before using bespoke legislative solutions. Legislating for particular circumstances risks undermining democratic values and the legitimacy of Parliament, and in some cases may be seen as biasing the system towards interests that are well-funded or well-connected and able to lobby for their interests. And you can certainly see with that America's Cup example how that argument might play out. Another thing is that too many bespoke solutions may undermine confidence and certainty in the general system and may incrementally shift the overall balancing of rights and responsibilities under that general system. It can also increase complexity in the law and increase the risk of error and unintended consequences, and just make it generally more difficult for people to understand what the law applying in a given situation is. And finally, something that's overlooked, I think, too often is the fact that bespoke legislation is resource and time intensive for Parliament, government submitters, PCO and others. And yeah, I think sometimes that cost is underestimated at the outset of these projects. When we get bespoke legislative proposals coming to LDAC, we tend to work through a number of questions with agencies just to kind of work through whether or not they've actually thought through everything. So perhaps it's useful if I address those questions now.
Yep.
The first question is whether the circumstances are sufficiently exceptional so that it's actually in the public interest to intervene on a bespoke basis. So as I mentioned at the outset, there needs to be a really strong underlying public policy rationale. So for example, in that America's Cup example, there was some broad national interest considerations in ensuring that the Cup Village was ready to go and we could meet the commitments that had been made around the running of the America's Cup. Bespoke legislation shouldn't be used as a matter of mere convenience. Just because Parliament can doesn't mean it should in a particular situation.
It's a really interesting point, Alison, just in the sense that as you've said what you've said, it's kind of one of those things that occurs to me that, oftentimes some of the issues that require bespoke legislation are actually about systemic issues with the law or systemic issues with policy. And there's kind of an interesting question, which I'd interested in your view, actually, in terms of maybe you need a bespoke piece of legislation now, but you shouldn't kind of leave the systemic issues unattended. Do you have a perspective on that?
Yeah, I do. I mean, often, if you have a bespoke solution kind of occurring to you, then it may be a signal that your existing law is not fit for purpose. And I think that in those sorts of situations, there might be a tendency to think that bespoke solution is the easy out. But as I mentioned before, there is a significant cost in terms of resources and time, and really it's not that much more efficient just to fix your small problem and kick the can down the road with the bigger problem. It may well be better just to grapple with the general law issue up front.
Despite the pressures that might exist, which is what you're pointing to.
Exactly. We all know how those pressures operate day to day. So yeah.
Indeed. Hey, I'm just conscious of time in our webinar today, and want to give enough time for our audience to ask questions. We've already got one, but would encourage others to raise questions as well, just in the Q&A box at the bottom of the screen. We're going to turn now to how we choose precedents to follow and how we incorporate those into proposed legislation effectively. And I've always been intrigued by precedents. I'm not a lawyer, I'm an economist. So looking at the law and how people in the law think about precedents is always fascinated me to some extent. So turning to you again, Alison, when should we follow precedents in existing legislation?
It's a good question. There's a bit of a balance to be struck here between not reinventing the wheel and at the same time not adopting something that's not fit for purpose in your context. And I think the starting point really is being really, really clear about what your policy objective is, what the problem that you're trying to solve is, so that you can actually work through with your proposed solution, be it in the form of a precedent you've picked up from elsewhere, whether or not that precedent's actually going to fit, and what kinds of modifications you might need to make for your context and for your policy objectives to be achieved.
It's interesting, isn't it? I mean, I guess if I just turn to John, because what you've said intrigues me somewhat, in the sense that I have a sense that sometimes perhaps it's tempting to go sort of almost forum shopping for the precedent that best suits your argument. So how should we choose which precedent to follow, John?
Well, I mean, I think you're right. I mean, I think there are advantages in using precedents. As Alison said, you don't want to reinvent the wheel, and often existing legislation has reflected quite a lot of effort by a lot of people to achieve something. But you do need to be very careful to understand the context in which that legislation operates and the objectives that it has and how they relate to yours. And often there will be different contexts, there will be different circumstances, and there will also be different drafting styles. Drafting has evolved quite a lot over time. So I guess it's being very clear about what is the same as what you want to achieve and what is different, and working with your drafter to reflect that.
Have you had particular experience with this kind of issue, John, in some of the work you've done before?
Certainly in the local government legislation, there's been a long-standing practice of reenacting acts with some policy changes, but some not. Some changes that nobody has done the policy work, so basically it's just the same provisions or a new version of the same provisions. But I mean, that is really dangerous in itself, because the context, like all the legislation fits together. It's like you're updating half the cogs in a wheel. I mean, sorry, in a clock, but not the others. And sometimes the time no longer reflects the reality on what you want to achieve.
Yeah, it's interesting too. I was just reflecting on the work on local government that you and I have done over time, and the number of times I've heard arguments, often from the legal profession, about the fact you shouldn't change the words because there's this kind of almighty precedent and build up of case law and stuff like that. Where do you think that fits in this context?
I have heard that argument several times, like destroying books and books of jurisprudence. I think there's no reason for changing things just for the sake of changing them, but often there is a good reason for changing. And so I think, again, it's understanding what you're trying to achieve and how and whether the precedents are still relevant to that.
It's interesting actually, because I guess turning again to Alison, just to come close to finishing off the Q&A session. When as an economist, I've often thought that when I look at some of the legal precedent stuff, that it's a recipe for maintaining the status quo. I think what John's saying is that's not necessarily the case, but what are some other common issues that arise in considering whether to follow a precedent?
I think the key one is really, if you are considering change, just to be thoughtful about what unintended consequences that might bring with it. So if you have a particular model that's been applied in other contexts and you suddenly do something different in this context, that may suggest to a court that because it's worded differently or shaped differently, that it was intended to have a different outcome. And it may also mean that when they're interpreting those other precedent models, that they say, well, this word wasn't used here, so therefore this obviously wasn't intended. So you just need to be thoughtful about how it potentially impacts on interpretation of other parts of the law where you're borrowing from as well.
It's interesting too, and you obviously work in a department that has quite a lot of international connections in one form or another, and often presumably in a legal sense there's a bit of a temptation to borrow provisions or precedents from other jurisdictions, even if they're kind of a little bit like New Zealand. Do you have advice for the audience today in terms of those international precedents?
Some areas it's not so hard. So if you're for example putting together legislation to implement a particular treaty or set of treaty obligations, then picking up a precedent from another jurisdiction is probably not so hard. But I think the key thing is just really working through what the differences are in that jurisdiction in terms of the institutions that will be overseeing the law, the kinds of statutory models that are commonly used. I mean, different jurisdictions have different drafting styles. So, for example, offences may be constructed slightly differently, and we really do need to make it our own. So it has to be. You can pick up a model from elsewhere, but we need to infuse it with our Indigenous flavours. Yeah,
it's really interesting. I mean, just to summarise this part of the webinar, it seems to me that there's a really strong case for precedent being really carefully considered, but also they're not to be bound by the status quo. I think we're saying that all aspects of precedent have to align with the scheme of the legislation and arguably the policy that's being developed as well as its purpose. And I think your warning, Alison, is to make sure that you're understanding the basis of the precedent and the context in which that precedent arose. But also get really clear, if you're not going to follow precedent, given the legal framework here, be really clear about why that's not happening and write that down as well. So that's the end of the three parts to the webinar and our Q&A. I want to thank the panel very much for the contribution, but their role isn't quite finished. We have a number of questions